Oklahoma has a landlord-friendly breaking lease framework with a statutory duty to mitigate that provides basic clarity while giving landlords broad discretion. The governing law is found in the Oklahoma Residential Landlord and Tenant Act, Oklahoma Statutes Title 41, which addresses the landlord's obligations when a tenant vacates early and the framework for calculating damages. If you're a landlord or tenant in Oklahoma, the state provides a workable framework that favors property rights while recognizing the landlord's obligation to minimize losses. Let's start with the landlord's duty to mitigate damages. Under Oklahoma Statutes Title 41, Section 129, when a tenant abandons the property or breaks the lease, the landlord has a duty to make reasonable efforts to re-rent the unit. Oklahoma's mitigation requirement is statutory, giving it clear enforceability. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without attempting to find a replacement tenant. The landlord must take reasonable steps to re-rent, advertising the unit, showing it to prospective tenants, and accepting a qualified applicant who meets the landlord's legitimate screening criteria. The landlord is not required to give the vacated unit priority over other vacancies or to lower the rent below market rate. But the landlord must treat the vacancy the same way they would treat any other vacancy in their portfolio. If the landlord re-rents the unit, the departing tenant's liability is limited to rent during the vacancy period, plus the landlord's reasonable re-rental costs, advertising, cleaning, make-ready work, and leasing expenses. If the landlord fails to make reasonable efforts, the departing tenant can argue that damages should be reduced by the rent the landlord could have collected through reasonable mitigation. Early termination clauses are generally enforceable in Oklahoma. The state does not have a specific statute capping early termination fees, and Oklahoma courts enforce reasonable contractual provisions. A clause requiring 30 to 60 days' notice and a fee of 1 to 2 months' rent is typical and enforceable. Oklahoma's contract law principles govern. The fee must represent a reasonable pre-estimate of anticipated damages rather than a penalty. Oklahoma courts generally give deference to negotiated lease terms. Many Oklahoma landlords include both an early termination option with a defined fee and notice period, and a lease break damages provision for situations where the tenant simply abandons without using the formal termination process. This two-tiered approach incentivizes tenants to communicate and cooperate rather than disappearing. Military members have the right to break a lease under the Federal Service Members' Civil Relief Act. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Oklahoma has a significant military population. Tinker Air Force Base near Oklahoma City is one of the largest Air Force installations in the country, home to the Air Force Sustainment Center and a massive workforce. Fort Sill near Lawton is the Army's primary fires training center. Altus Air Force Base near Altus and Vance Air Force Base near Enid also generate military rental demand. SCRA lease terminations are a regular occurrence across Oklahoma's military communities. Landlords near Tinker, Fort Sill, Altus, and Vance should have standardized SCRA processes. The military population rotates regularly, particularly at Fort Sill, where training cycles create frequent turnover, and efficient handling of military lease breaks is essential for maintaining occupancy. Oklahoma does not have a comprehensive state statute providing enhanced lease-breaking protections specifically for victims of domestic violence in the same detailed framework found in states like Oregon or Washington. Oklahoma does have the Protection from Domestic Abuse Act, Title 22, Section 60 and following, which provides protective orders. However, the Act does not include a specific provision allowing early lease termination based on domestic violence status. Domestic violence victims in Oklahoma who need to break a lease must generally rely on general contract principles, negotiate with the landlord, or seek assistance through advocacy organizations like the Oklahoma Coalition Against Domestic Violence and Sexual Assault. Some Oklahoma landlords voluntarily include domestic violence termination clauses in their leases, which is a recommended best practice. Tenants in Oklahoma may break a lease if the landlord fails to maintain habitable conditions. Under Oklahoma statutes, Title 41, Section 118, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises in a fit and habitable condition, keep common areas safe and clean, and maintain essential services including plumbing, heating, and electrical systems. If the landlord fails to maintain the property and the failure materially affects health and safety, the tenant has remedies under the Act. The tenant must provide written notice to the landlord identifying the specific deficiency. The landlord then has 14 days to make the repair for non-emergency conditions. If the landlord fails to act within 14 days, the tenant may terminate the lease by providing written notice. For emergency conditions, such as no heat during winter, a gas leak, or sewage backup, the response time is shorter. The tenant should provide notice and allow a reasonable but expedited period for emergency repairs before terminating. The notice and cure process is essential in Oklahoma. The tenant must follow the statutory procedure: written notice, the 14-day repair period, and then a termination notice if the landlord fails to act. Simply vacating without following the process weakens the tenant's claim and may result in liability for the remaining rent. Oklahoma also recognizes constructive eviction as grounds for lease termination. If the landlord's failure to maintain the property or the landlord's affirmative actions, shutting off utilities, changing locks without authorization, removing doors or windows, make the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time to establish constructive eviction. Oklahoma has specific provisions regarding abandonment that are relevant to the breaking lease context. Under Title 41, Section 130, if a tenant abandons the property, the landlord can retake possession and re-rent the unit after providing proper notice. The statute provides a framework for determining abandonment. The tenant's absence from the property, non-payment of rent, and removal of personal belongings are relevant factors. The landlord should document evidence of abandonment before entering. When a tenant abandons, the landlord must still fulfill the mitigation duty, attempting to re-rent the unit promptly. The departing tenant remains liable for damages, vacancy rent plus re-rental costs, reduced by what the landlord collects from a replacement tenant. Oklahoma's eviction process is relatively fast. The landlord can file for eviction with just 5 days' notice for non-payment of rent. This fast timeline means landlords can quickly regain possession when a tenant stops paying as part of breaking the lease, which reduces the overall vacancy period compared to states with longer eviction timelines. Oklahoma's energy economy creates specific breaking lease dynamics. When oil and gas prices are high and drilling activity is strong, energy workers flood into communities near active plays, particularly in central Oklahoma's Scoop and Stack formations and in western Oklahoma. When prices drop, workers leave, often breaking leases. Landlords in energy-dependent communities experience cyclical waves of lease breaks tied to commodity prices. Screening and lease structuring in energy communities should account for this volatility. Shorter lease terms, 6 months rather than 12, reduce the financial exposure for both parties when the market shifts. Early termination clauses with reasonable fees provide a clear mechanism for workers who need to relocate when projects end. From a practical standpoint, Oklahoma's rental market is concentrated in 2 major metros, with secondary markets scattered across the state. Oklahoma City is the state's largest and most active rental market. The economy is driven by energy, aerospace, and defense, including Tinker AFB, healthcare, government, and a growing technology and bioscience sector. When a tenant breaks a lease in Oklahoma City, re-rental times vary by area. Desirable neighborhoods like Midtown, the Paseo, and Nichols Hills can be re-rented within 2 to 4 weeks. More suburban or outlying areas may take slightly longer. The overall market is moderate with steady demand. Tinker AFB's massive workforce generates both military and civilian rental demand in Midwest City, Del City, and the Southeast Oklahoma City metro. SCRA terminations from Tinker are a routine part of operations for landlords in this area. Tulsa, the state's second-largest city, has a moderate market driven by energy, aerospace, including American Airlines maintenance facility, healthcare, and the Tulsa Remote program that has attracted thousands of remote workers from across the country. The Tulsa Remote influx has strengthened demand in downtown and midtown Tulsa, and has also created a population of tenants who may break leases if their remote work situations change or they decide to relocate again. Re-rental in Tulsa's desirable areas is moderate, typically 2 to 4 weeks. Norman, home to the University of Oklahoma, has a tight student-driven market. OU's enrollment creates strong seasonal demand. Breaking a lease in Norman during the spring or summer results in quick re-rental as incoming students look for housing. Mid-semester breaks take longer. Stillwater, home to Oklahoma State University, has a similar student-driven dynamic. Edmond, a northern Oklahoma City suburb, has a strong family-oriented market with steady demand. Lawton, adjacent to Fort Sill, has a heavily military-influenced market. Fort Sill's training cycle creates regular turnover, and SCRA lease terminations are a constant. Landlords in Lawton should treat military lease breaks as a core part of their business, pricing turnover into their operating model and maintaining efficient make-ready processes. Enid, near Vance AFB, and Altus, near Altus AFB, have smaller military-influenced markets. Broken Arrow, Owasso, and other Tulsa suburbs have growing family-oriented markets with steady demand. Muskogee, Bartlesville, and smaller Oklahoma communities have more affordable markets with limited applicant pools. One best practice for Oklahoma landlords include a clear early termination clause in your lease that defines the notice period, the fee, and the process. Oklahoma's URLTA framework supports reasonable early termination provisions. A typical clause might offer 60 days notice and a fee of 1 to 2 months rent. Having a defined path for early departure encourages tenants to communicate rather than simply abandoning the property, which creates a worse outcome for everyone. Another best practice: begin re-rental efforts immediately when a tenant breaks the lease or when you discover abandonment. Oklahoma's statutory mitigation duty under Section 129 means you must act promptly. Document every step: listing dates, advertising channels, inquiry counts, showings, and when you accepted a replacement tenant. Your documentation proves you fulfilled your obligation and establishes the departing tenant's actual liability. A third best practice: for landlords in energy-dependent communities, structure your leases to account for the volatility of the oil and gas market. Consider offering shorter lease terms during active drilling periods. This reduces the frequency and financial impact of broken leases when the market shifts. Include a clear early termination provision, so energy workers have a defined path for leaving when their assignment ends. And maintain a continuous marketing presence so you can fill vacancies quickly when they occur. Oklahoma requires landlords to hold the security deposit in an escrow account at a federally insured financial institution in Oklahoma. The deposit must be returned within 45 days of the tenant vacating, along with an itemized statement of any deductions. There is no statutory cap on the deposit amount. It's governed by the lease terms. If the landlord fails to return the deposit within 45 days, the landlord may be liable for the full deposit amount plus damages. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Oklahoma breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.